So, Kareema, I heard sugar is out, dope is in.
She really wanted to say that.
I did.
Thanks, Alicia. Yes, so unless you've just returned from an expedition to the Antarctic or if you're coming off a social media cleanse, you will have heard of the Constitutional Court decision which declared um, certain provisions of the Drugs and Drug Trafficking Act and the Medicines and Related Substances Act unconstitutional. They were declared unconstitutional on the basis that they infringed upon the right to privacy entrenched in Section 14 of the Constitution. The Constitutional Court decision essentially, I mean, it's a 74-page long decision, which is long even
Very long.
by
very
our
long,
standards.
Very long.
Essentially, what it means is that it's now legal for adult persons to cultivate cannabis, to use and possess cannabis in the privacy of their own home.
So, can I smoke weed at work, in my office? No one's watching.
No, Alicia, for those of us who work with you, thank God not. But the Constitutional Court decision is very clear. You can only use and cultivate cannabis for private consumption in the privacy of your own home. So that means for us today that the commercialization or the trade in cannabis and cannabis products is not yet legal in South Africa, but many believe that it is South Africa's first step towards joining the ranks of countries worldwide in which the trade in and use of cannabis, whether it be for medicinal purposes or recreational purposes, is legal.
So the trade in cannabis or weed and marijuana is a massive industry. There's huge potential for it, for the local market, for the agricultural market, for the manufacturing market, for fast-moving consumer goods. So should it become legal in South Africa, as in many other countries in the world, there's a wide variety of products that one can consume. There is actual weed products that you can consume, if we can get my slides to catch up with me. There's the actual product that you can consume, which can be sold in cute little packages like that to make it palatable to the rest of us. There are also what I call juju gums that you can also get involved in. There are, if you want to get your high from the chocolate and the weed, there is cannabis-infused chocolate products that are also available in this industry and market. Similarly, too, there's something for the pets. I don't know if it will make them bark less or more. Hopefully less. And then in addition to that, there are also body products. There are creams, hand creams, foot rubs, things to relax you with. Maybe I could do with a few on this presentation. So there's a wide potential for this industry. Now that we're thinking of what people can do, Canada's joined the ranks of making the legalization of cannabis legal, yay. And so brewery industries are looking into cannabis-infused beers. Not sure what that would taste like, but it's interesting.
Yeah, South African companies are already starting to realize the potential in the industry. For instance, there's a brewery in Durban that has just released a hemp-infused beer called Durban Poison. So we've got a picture, Alicia, right there. Yeah, so the beer contains hemp or is infused with hemp, and just quickly, hemp is a form of cannabis that is already legal in South Africa, but it contains very little to no THC, which is the chemical in cannabis that's responsible for the high feeling. So it's already huge potential.
And everyone in this room, why do we care about cannabis legalization, trademark lawyers or trademark brand owners? Why are we interested?
Yeah, well, brand owners need to start developing a strategy now so that when cannabis is legalized, they can take full advantage and ride the marijuana wave. So with new products and services, I tried it, it may not have worked. With new products and services, naturally a strong IP focus is required, and any strategy that brand owners adopt must necessarily include trademark protection. So if we take Durban Poison as an example, the brewery responsible for this product may wish to register Durban Poison as a trademark. The internet tells me, because I have to research this, that Durban Poison is the street name of a strain of cannabis. So one would imagine that it's a very clever, cheeky name for a product, a beer product infused with cannabis or hemp, but there are a few potential obstacles.
Talk about obstacles for trademark registration. The first one that sort of comes to mind is Section 1012, which prohibits the registration of a mark that's inherently deceptive, that's contra bono moris, or that's likely to give offense to a class of consumer. Talking about trademarks that give offense to classes of consumers, what that means over time has definitely changed. FC UK is a registered trademark, so is the ZAP sign, you'd be surprised. But there's been a movement about what we find offensive as a society in general. Surprisingly for me, Fat Bastard over there was refused registration because it did give offense to a class of consumer in 2007. I must admit I'm a lot more offended by the ZAP sign than that one, and probably for that reason, the proprietor of the Fat Bastard trademark was able to overcome the provisional refusal by filing submissions, and those submissions included arguments that they've received no complaints from consumers about the mark being offensive, and for that reason it's probably proceeded to registration. The little B device there in the middle, on the other hand, has remained provisionally refused, and considering the current climate that we find ourselves in, it's likely to remain a mark that's probably likely to give offense to a class of consumer and will not proceed to registration anytime soon.
Yeah, so just going back to our Durban poison example, although objectively the words are not offensive, those who catch the reference may take offense, but given the state of the register at the moment, it's unlikely that that will occur. And I'll also just what Alicia said earlier about the morals maybe changing or evolving over time, we find that the face of cannabis has changed thanks to some fancy marketing footwork. I mean, you get products labeled with artisanal and luxury, and words such as microdosing, which is all the rage now, are used, and then you get very trendy, sexy packaging, and what I'm told is a very professionally run industry. So all of this has gone a long way towards altering marketing perceptions, at least globally, but one finds that that has sort of seeped in through to our local markets, at least on the trademarks register. For instance, we've got, I did a search, and in 1998, a trademark application for a leaf, a cannabis leaf, was refused registration. But then fast forward to 2015, where an application for the word mark cannabis clothing was accepted. So already we start to see the altering of perceptions, at least at the registry. So cannabis is, dare I say, no longer, it doesn't evoke, feelings of backyard or back alley dealings and dingy vibes, but has become sort of hipster and trendy. So possibly Durban poison is registrable in our current climate.
At least from that perspective, I mean, I think another obstacle that I'm thinking of is Section 10.2, where something has become customary in the common language, or it designates the trade of something. Can you really then be allowed to monopolize that word to the exclusion of any other party? For some of us who didn't know, like me, our clubbing days are long ago.
Sure, Alicia.
Melktert is a shooter that's vodka infused with condensed milk and other milk products. And there was a third party who was interested in registering that trademark. And other people went, oh no, we all want to be able to use that mark because that's the name of a shooter. It's something that's become customary and used in trade. So, from that point of view, I'm not sure whether Durban poison will fly. In addition, whether it's become customary, it might also just be plainly descriptive. There's Chisanyama, for those of us who don't know. It's a place where people gather to braai meat. And someone wanted to register that as a trademark, and the trademarks register said no. Well, they're trademark lawyers, better. And we said, do something different with it. So they spelled it differently. They jazzed it up as a logo. They listened to their lawyers and added distinctive elements like the flame, very distinctive. But the point is they've got registration in that mark, and ordinary consumers and other people can use Chisanyama.
Yeah, so that is a creative way of overcoming a refusal by the registry. So the brewery that we're talking about may want to, zhuzh up the Durban Poison brand or the logo. But another argument then on the descriptive issue is that the beer in question is infused with hemp, which is a different type of cannabis, and not Durban Poison, the Durban Poison variety of cannabis. So one would imagine that it is therefore not descriptive of the goods in question. But then an argument like that may possibly lead you into trouble in terms of Section 1012 again, because Section 1012 also prohibits the registration of of a mark which is deceptive. So it's arguable that a product called Durban Poison, which contains no Durban Poison, may be misdescriptive and deceptive. And so there's another obstacle. There are problems for Durban Poison.
Durban Poison is not seeming like it's going to pass any sort of muster, and it will definitely encounter difficulties.
But you can contact us if you're the brewery in question. We'll help
In
you.
case we never know, we never know. But apart from sort of trademark obstacles that a trademark may face, there are also advertising law, labeling problems. If we think of how heavily regulated the tobacco and alcohol industry are, equal regulation would probably apply to the cannabis industry if it were to become legal. There are also plant breeders' rights, plant breeders' variety laws, which will bring you back to Section 1012. I'm not starting to like this section because then your application will be contrary to law. So if you do want to register a trademark in this space, definitely come chat to us first.
Yeah. But also, apart from trademarks, brand owners should also be aware of other forms of IP protection available to them. What we see is that producers of marijuana and cannabis or cannabis products globally, they're constantly trying to develop new strains of cannabis to keep their consumers interested.
Or high.
Or high. And so, that genetically modified cannabis could qualify for patent protection, copyright protection, and even plant variety protection. And then you've got the formulations and indications. It's all very technical. But brand owners should just keep this in mind. There are other forms of IP that you can exploit.
And since, green or weed is the new frontier, one shouldn't forget about domain name registration. Given the ease with which you can register a domain name, the lack of formal requirements up front for the registration of a domain name, it is an interesting space to be in, especially since you would like to dominate the internet. That would probably explain why cannabis.co.za is already registered. So too is durbanpoison.co.za. There's also the possibility that a new top-level GTLD would be released for .cannabis. It's also a space that you would definitely want to stake your claim to, given the ease of registration in that space.
Yeah, so for now, just to wrap us up, cannabis is not yet legal, so the commercialization of cannabis is purely theoretical. The Constitutional Court decision only currently makes it legal for adult persons to use cannabis in private, but legitimate commercial opportunities inevitably shape policy, and so one could imagine that legalization is on its way and possibly even in our lifetime.
Definitely. And for that reason, you want to choose a trademark should you want it to go into the space, given its wide potential. You're not only selling weed, you are selling derivative products. You want to choose a trademark that's unique, but that's also sexy and marketable. So in order to find that balance, you definitely want to speak to your trademark proprietors, or not proprietors, trademark lawyers, so that you can have a sword to fight off other people who want to use something similar to you, but also something that can protect you when you are in that space.
Yeah, so the takeaway is choosing a predictable brand from the beginning is essential. Thank you.
Voila, we didn't need any cannabis.
There are no samples.
So much, Alicia and Kareema. That was very insightful. We have a couple of questions here for you, briefly. Starting with the first question is from Anonymous. What IP protection can enterprising individuals obtain for newly created strains of marijuana?
Yeah, so I mean, obviously trademark protection, naturally, and then also I discussed formulations, medical indications, or even non-medical indications. So even if you've got a hemp lotion or a cannabis-infused chocolate, or if you believe, if it's unique, if it's novel, if the requirements for patent protection are met, you can get a patent. And then there is a separate set of requirements for copyright protection, but that is an alternative. And then plant variety rights and plant breeders' rights and those kind of things. I'm not a specialist in that, but those all apply. So there's huge potential.
Fantastic. Thank you. The next question is also from Anonymous. Did Woolies actually sell infused burry, or is that fake news?
We don't know, so we're going to go
Alicia,
with
I'll let
fake
you take
news.
that.
I don't know. I
Yeah.
mean, it would be, I assume, depending on what it was infused with, it would be unlawful to sell it. If it was perhaps infused with hemp, they could probably get away with it. If it was infused with a strain of cannabis, it would be unlawful to trade in something like
I
that.
don't know how good that would taste.
Yeah. Plus, we trust Woolies. They're a good, loyal brand, so hopefully whatever they did was legal.
And next question from myself. Would anyone be able to claim exclusivity for the cannabis leaf device, do you think?
Well, there are already marks on the register incorporating the cannabis leaf. But I guess it would depend. It may be descriptive if you're looking at the goods in class, like agricultural goods or the plant. It may be suggestive. So if the requirements in terms of the Trademarks Act are met, your mark must be distinctive. And so if you can prove that, if you can pass that hurdle, you may be able to register it. But yeah, it remains to be seen. I guess it just depends on what rights exist and what class of goods you're looking at.
And I think also for me, I mean, if you think about whether it's reasonably required for use by other consumers, I think there's an argument to be made there that you can't have exclusivity in the depiction of something if your product contains that product. So if you have hemp clothing, which, you know, the fiber in the clothing has something to do with hemp or cannabis, and there's some element of it, you can make some argument. I think it would be a bit difficult for one party to the exclusion of everyone else to have that device, depending on the goods and services that you want to register it for.
And there's always an opportunity to disclaim that element or to add an admission, like Gerard spoke about earlier. So.
Yes, perfect. And our last question before we break out. Could Cafe 420 in Sandton register the name as a trademark?
Okay, there's obviously Cafe 420 clearly means something that I don't understand. Does it mean nothing?
Anonymous, would you like to?
Who asked it?
Because Cafe 420, if I look at it, there's nothing about it that jumps out at me and seems that
like
it's a
Durban
problem.
poison.
So is it the name for something? Is it who's Cafe 420? Anonymous,
Okay.
please stand up.
No one wants to admit it.
I mean,
generally,
inherently, I
generally,
think there's
yes.
nothing wrong with
Yeah,
Cafe
yeah.
420, but unless it's a reference to something that I don't understand, Cafe 420, depending on the goods of services, again, seems registrable.
Yeah. Okay.
Yeah.
Oh, there we go.
You see,
Oh,
you see.
we learned something new.
You see, so we didn't know that. So if we were the examiner, we would have
would
let
say
you
yes.
register cannabis. You could probably then object to the registration to say that it is something that's reasonably required for use by other people who understand the reference.
But
Yeah.
unlikely, especially given our poll for Durban poison. So.
So yeah, good.
Okay.